Welcome back to Company Law 2. So we continue with discussion of corporate finance, particularly shares. The last time we met, we discussed some of the basics of shares in terms of what share meant, some concepts related to shares, the no par value concept, the legal incidence of shares, payment for shares, issue of shares. We discussed all that. So fortunately for you, I think that recording is available and we'll share with you. You can always go back to it if you have forgotten some of the explanations. So this morning, we would like to discuss classification of shares and other related matters. So as I have indicated, we are doing what we call the textual analysis. We take the text, we analyze it, and if there are relevant case law which illuminate the relevant text, that we consider that as well and provide some practical illustrations. So that is how we are proceeding so that we understand the law properly. And as I've told you, in real life, when there's a dispute in the court, we come back to the text itself to try and make sense of the text and see how it helps us to resolve the particular problem on hand. So let us keep that in mind. So we have already noted that in terms of the rights associated with shares is very much dependent upon the terms of issue. The terms of issues of the shares would actually give us a good idea of what that share is. And that has implication for classifying shares. And that is why Section 49(1) of our Companies Act, Continental Act 992, make the point that the registered constitution of a company may provide for different classes of shares by attaching to certain of the shares preferred, deferred, or any other special right or restriction, whether as regards dividend, voting, repayment, or otherwise. So the point to note is that it is permissible for the company, by virtue of its registered constitution, to provide for various kinds or types of shares. And these shares may differ from one another with respect to maybe payment of dividend. Is it the case that a particular shareholder will get his dividends before the others? Is it the case that a particular shareholder will be given a certain assured sum of dividends and the rest will not be given that? So that is a point of differentiating shares. It can be in respect of payment of dividends, either the timing for the payment of the dividend or maybe the formula for the payment of the dividend. Again, it can also be in relation to voting. As a general rule, each share carries one vote, but it is permissible for the company by its constitution to provide some other permutations regarding voting, so long as the mandatory requirement of the law that each share carries one vote, for example, is not compromised, but other possibilities can be done as far as the shares are concerned. So let us keep that in mind. Again, when it comes to repayment, it is possible for the company to also create shares and say that, okay, for these shares, it's not going to remain in the company forever. That is to say that these shareholders, their monies will be returned to them at future date or under certain circumstances. Either they will request that the company should give their money back to them and take their shares, or some other arrangements. Or it may well be that when the company is winding up, especially when there's a voluntary winding up, meaning that the company is solvent, the company is a going concern, it is able to pay its debts and liabilities, but for whatever reason, the members just want the company to be closed down, want it to be dissolved, so it's wind up. Now, once the company has settled all creditors or all debts that it owes, and it is still left with some money or some assets, those assets are for the shareholders. Now, how the remaining assets are distributed to the shareholders can also have some differentiation, so that maybe some shareholders will be given some of the remaining assets or income first, or before others, or a certain fixed amount of the income or assets left will be given them before the rest will be distributed to the rest. So all these are some of the ways by which the company may create different classes of shares. In any case, if you look at the last word, or otherwise, that is to say that the law has provided broad latitude, freedom for the company to create all manner of classes of shares, more than the few that we have actually gone through in the list. So if you remember, when we're discussing the effect of constitution when registered, one of the things we noted was that where the constitution has, for example, provided that someone has the right to appoint directors, that provision shall have effect, regardless of the fact that the person is a member or not a member, or whatever the case may be. Now, all those things are reminding you that the company by its constitution can do anything. It can do so many things, so long as it's not against the provisions of the law. So let us keep that in mind. Now, another point to note is that maybe you set up like a company, and some people have sacrificed to let the company come about, and they may want that sacrifice that they have made to actually be recognized, have some influence in the life of the company. And for that matter, a particular class of shares may be created for them. Probably the deferred shares that we are talking about. And they will say, okay, ultimately, we are the real owners of the company. So we will prefer to laugh last, as they say that he who laughs last best. So when it comes to payment of dividends and everything, we will be the last to be paid. Let everybody be sorted. Then what is left, everything will be ours. So you create like a deferred shares for them, and that may be like maybe a special funders share class or something like that, as the case may be, and so on. Now, 49.2 makes a point that shares are not of the same rank, the same class. Shares are not of the same class unless they rank at the same rate for all purposes. And this is reminding us of the different classes permitted to be created. Your shareholders, despite the fact that your shareholders of the same class, it doesn't mean that you have the same bundle of rights, the same bundle of privileges. So you can belong to the same class, or, like put differently, you are all giving shares the same day, but because there are different terms of issue, you are not necessarily the same class shareholders. I think that is, let's put it that way better. Now, you are only considered as having the same class of rights where the shares rank at the same rate for all purposes. In other words, when it comes to dividends, the same arrangement applies to you. When it comes to voting, the same arrangement applies to you. That way, we can say that your shares are in the same class because they rank at the same rate for all purposes. But where you have a situation, A, B, C, they got shares from the same company. Now, C is a deferred shareholder in the sense that he will have to wait for all shareholders to be given their dividends. C is giving the power of, if you like, breaking a tie. If there's a deadlock in the general members meeting and the votes are equal, his share is given the right to break the tie. Now, in that situation, you cannot say that the shares of A, B, and C are of the same class because they don't rank at the same rate for all purposes. You see some differentiation. So very soon we're talking about class rights. Class rights are those rights which are enjoyed by shareholders who shares fall within a particular class. So where you have class rights, by definition, those rights which are supposed to be enjoyed by shareholders in a particular class. Now, what that means is that if there's going to be any change regarding rights enjoyed by shareholders in that class, it will not have to be done arbitrarily. It will have to follow strict procedure prescribed by the law and the constitution of the company. And that is what Section 51 reminds us, that where at any time the shares of a company are divided into different classes, the rights attached to a class shall not be varied unless otherwise expressly provided for in the constitution of a company. So once you have a class rights, the class rights are guaranteed, protected, unless there's a specific procedure for varying or changing them. They cannot be changed by the company just at a will. And in fact, if you remember discussion of alteration of the constitution of the company, you noted that when it comes to alteration or amendment of the constitution of the company, as far as class rights are concerned, you cannot just use the normal procedure. So you go back to section 30 of Act 992, just in case you have forgotten the procedure for amending the constitution of the company. Again, where the constitution of a company expressly forbids the variation of the rights of class or contains provisions regarding that variation and expressly forbids an amendment of the provision in respect of the variation of rights, the right shall not be varied, and the provision for variation shall not be amended, except with the sanction of the court under a scheme of arrangement in accordance with section 2.3 now. Now, this provision is very important. Later on, we'll be discussing the topic we call the mergers, acquisition, amalgamations, and arrangement. There are some transformations which occur in the life of the company. Some of those transformations are such that you need to get judicial approval before you can go ahead. And this is one typical example, that the constitution of the company has provided the class rights, and then there's also a provision in the constitution which says that under no circumstance shall the constitution of the company be amended in order to vary or change the class rights. Now, where the constitution has made such a provision, then it is a very, it has more or less like the effect of, entrenched clause, quote and unquote, as it were. But it may be necessary for the company to take advantage of the changing business environment, changing macroeconomic climate, and so on, and may need to make certain changes. And those changes would also involve varying the rights of the class. But here is the case, there's a provision in the constitution says that you cannot vary the rights of the class. So what do? Now, where that is the case, it implies you cannot use the simple amendment procedure in the constitution of the company to amend. So you need to bring yourself within what we call the scheme of arrangement. And the scheme of arrangement is a special procedure for making changes or amendments concerning the company, which ordinarily cannot be done through the usual processes of the company. And that is why the court will have to come in. So if you go to section 239, where there's going to be arrangement or compromise between the company or between class of creditors or members or any class of members, the court is supposed to come in on application of the persons affected or interested in the matter. And if you look at the 2.3 now, various stakeholders have been listed there. The company itself, the liquidator, the administrator, any other person interested in the matter. Now, the point about having the court intervene as far as arrangements is concerned is to ensure that people are fairly treated, particularly talking about evaluation of class rights. Where you have members of the class who are not interested, for example, in having the proposed amendment so that their rights will be varied. The courts, which is superintending over the process, would order that let the interest of the dissentient member who does not want the proposed amendment of the class variation to go on, let have his or her interest valued, and then let the company, for example, buy him out so that they will be cleared for the remaining members who are willing to have the amendment to go on to proceed. So let's take note of that. So where there is no express provision in the constitution of the company forbidding variation of class rights, then just as the company can pass a special resolution to amend its constitution, it can also pass a special resolution amending its constitution by inserting in the constitution provisions regarding variation of the class rights, as it were. So just in case we've forgotten special resolution, a special resolution requires that notice of it, the proposal to pass it is published as part of the notice convening the meeting. And then when the meeting is convened, it must secure 75% or 3/4 majority of the members, as it were. So let's keep that in mind. So where there is no express prohibition, where there's no express prohibition that the class variation cannot be done, then the company can just pass a special resolution. But then where there's an express prohibition, that is where Section 52 is taking us to Section 239, that yes, you can have variation of class rights where there's express prohibition, but that variation will now have to be done as a scheme of arrangement. And a scheme of arrangement would involve the court so that the various stakeholders will have their interests properly protected. Yes, and then somebody indicated something. You have a question to who mark the 52? You can put up your hand so that you can raise it. The one who highlighted the 52, put up your hand so that I will release your mic for you. Okay, Emmanuel. Yes, Emmanuel.
My Lord, and thank you. My Lord, I highlighted it because when you are teaching, I try to also make notes out of what you are just teaching us so that it will be easier for me to also follow up when I'm doing revision. That's why I have highlighted that session to draw my attention to it.
All right, no problem. That is fine. Good. So let's keep that in mind. So 54, an amendment under this section requires the prior written consent of the holders of at least 3/4 of the issued shares of each class, or the sanction of a special resolution of the holders of the shares of each class, and shall be deemed to be a variation of the rights of each class. So, of course, just reinforcing the point you've made that to do the amendment, a special resolution will have to be passed. But the special resolution will be passed by all the members, as it were. But in addition to that, before you even put the proposed amendment to special resolution, you must have obtained written consent of 75% of those who hold the shares in a particular class that you are seeking to vary their rights. So you need to collect, if you like, the signatures of the written consent before you move on to do any other things. So let us keep that in mind. And just to let you know how the law tries to protect the rights of shareholders, accrued rights and all that. 55 is insistent that regardless of what you have in your registered constitution, under no circumstance can the company vary class rights unless it has obtained written consent of at least 3/4, that is 75% of the issued shares of that class. So you notice that it's a very tall order. It's a very tall order to have variation of class rights. It's not that simple because the levels are many. Because if you look at it, you start from the 53. It was about special resolution. That would be like the last act, right? 4, that you should get a prior written consent of holders of at least 3/4 of the issue shares of each class. So the 54 is even talking about each class, not only the class you are going to vary. And then we come to the 55, that is not enough for 3/4 of each class of the issue shares to have consented that yes, go ahead with the proposed class variation. The particular class whose rights are going to be varied must also provide the written consent, and you need 75% of people holding shares in that class to so consent in writing before you can go ahead to put the special resolution. Yes, let's take Emmanuel. Yes, Emma. Emmanuel sound is...
My Lord, please, can you go over the 5? Because I've been following. The 2 talks about the Constitution, 3 talks about the resolution, and the 4 talks about the 3/4 to consent from the special resolution, those who have shares in it. But the 5, I don't get it much.
Okay, so the 4 is talking about 3/4 of the issue shares of each class. So not necessarily the class whose rights are going to be varied. But the 5 is about the particular class whose rights are going to be varied. So it's like it's graduated. So you want to vary class rights, it's going to have impact on the share structure, membership structure of the company. So you need to get the particular class whose rights are going to be varied. At least 75% or 3/4 should agree in writing before you carry on with the process. And 2, you should get the various classes of issue shares, 3/4 of the members also agreeing in writing, that you can go ahead. And finally, the way is cleared for you to hold your general meeting and get special resolution, which also requires 3/4 of all those who will be attending the meeting to vote. So that is how it is. So the 4 is about 3/4 of the issue shares of each class, not necessarily the what do you call it, the particular class to have their rights varied. So if you look at the 4 and 5, in a sense, one would say that the drafter was just being extremely cautious. Because if you look at the 54, the latter part, which says that an amendment and this require prior written consent of the holder of at least 3/4 of the issued shares of each class, or the sanction of a special resolution of the holders of the shares of each class, and shall be deemed to be a variation of the rights of each class. So the 54 is talking about the possibility of having all the classes, their shares varied, so long as 3/4 of the members of each class are going to agree in writing that it should be so varied. And then the 5 is saying that, okay, if we cannot get 3/4 of all the classes of issued shares to so consent that there should be variation, in which case the variation will affect each of the classes of the issued shares, then the particular class which will have given the 3/4, or the particular class that the company is really interested in having their rights varied, they must necessarily have 3/4 of their members consenting in writing. So that is a relationship between the 54 and the 55. Emmanuel. Emmanuel is gone. Let's see. Emmanuel.
Hello, my lord.
Do you get the distinction?
Yes, I get a distinction. So, my lord, in all, if section 50, subsection 4 does not apply, then we move to subsection 5 to also determine the specific class or the particular class where the variation has to be done. That's all, right?
Yes, yes.
Thank you very much.
Right.
Thank you very much, my lord.
Now, where a resolution of a company, the implementation of which will have the effect of doing one of the following two things. A, diminishing the proportion of the total votes exercisable at the general meeting of the company by the holders of the existing share of a class. Or B, reducing the proportion of the dividends or distributions payable at any time to the holders of the existing shares of a class, is for purposes of this act a variation of the rights of that class. So 56 is giving us the litmus test within the meaning of Act 992. When we say variation of class rights, what does it mean? So 56 is giving us the statutory import or the statutory essence of variation of class rights as far as our company law regime is concerned. So variation of class rights is where you have passed the requisite resolution, as we have seen, the special resolution, subject to all the 3/4 prior written consent of the affected class members, and is seeking to do any of the following. Either it will reduce, that is diminish, the total number of votes which members of that class can cast in a general meeting. Mind you, we have said that it is possible for different class of shares to be given more votes than others. You can say that maybe those in the golden class A shares, when you are voting, their vote is going to count 3 times, and on certain types of matters. If that is in the Constitution, that will be it. But where you pass a resolution trying to change that and say that henceforth the total number of votes that holders of this class of shares can have is no longer this amount, was going to be that, then that is a violation of a class right. Or where particular class, maybe preferential shareholders with respect to dividends, are given a certain quantum, a certain amount of dividends when dividends are declared. So they are assured maybe a certain percentage. So anytime dividends are declared, that percentage will be given. Now, where you pass a resolution seeking to change that, that will be a violation of class rights. On the same vein, if you have a preferential shares with respect to, let's say, distribution of income or return of income, and you want to vary how the arrangements originally were. Now, if you do that, that is considered a violation of the rights of that class. So, as I indicated, Section 56 is just giving us specific examples of what count as violation of class rights. I think somebody hand this up. They mark something. Yeah, Mafreda. Yeah, Mafreda. Yes.
Yeah. Hello, my lord. Good morning.
Good morning.
Yeah, my lord, please. I was coming to ask a question, but I think you just threw light on that. And my question is, what are some of the activities that really influence a corporate entity to vary the rise of shareholders in a specific share class?
Okay, good. Thank you. You know, a company is operating in a very dynamic environment. The business environment is quite dynamic. And the business environment is also within the context of the micro economic environment or the climate, as it were, and then the global environment as well. Let's suppose that a company needs a certain level of funding, and the company is able to get maybe a strategic investor or a funds provider, as it were. And part of the requirement is that, okay, we are going to sink a hoping sum of $500 million in your operation. But before we do that, we have examined your corporate documents, your constitutions and all that. We notice that you have a certain class of shares, and then the members within that class, they have certain rights which we think are not in our interest. If we are to put this amount of money in the company for those class of shareholders to continue to enjoy those rights, it will be detrimental to our investment interest. So if you want us to put the money in, then you need to amend this aspect of your constitution. So like that's like one example. So then the company will need to get in touch, with the members of the class and go through the procedures as we are discussing. So practically, that is one of the instances in which there may be a need for variation of class rights. Or you can also have a creditors of the company. Probably the company has run into crisis and is distress. The company is distressed, to use the proper financial language. So a company in distress is trying to stay aloft in the business ocean and not get drowned.
Okay.
So it sits down with the creditor, and the creditor to say that, okay, we are not going to trigger procedure for liquidation, which we can do under the Corporate Insolvency and Restructuring Act. We are not going to do that, provided these privileged shareholders who have these class rights, they are not going to enjoy those rights, in which case we'll be comfortable that it is safe for us not to harass you, but to allow your company to bounce back. So for that compromise, for example, to be struck, it will warrant, the variation.
Okay, sir.
Yeah, so those are some of the instances.
Right. Thank you so much, my lord.
Okay, so now having understood the fact that it is permissible for the company to have various classes of shares, and also the possibility that the rights which are attached to a particular class, known as the class rights, can be varied so long as the requisite procedures are followed. And having understood how the variation actually work, the fact that it can apply to reducing the total number of votes exercisable by the class, or the reducing the proportion of dividends which is paid to that particular class, we will now proceed to look at more concrete instances of the classes or the types of shares, as it were. So section 51 addresses preference and equity shares, and I would like us to pay attention to the wording. 51(1). In this act, preference share means a share which does not entitle the holder of the share to a right to participate beyond a specified amount of money in a distribution, whether by way of dividend, or redemption, in a winding up, or otherwise. And any other share shall be referred to as an equity share. So section 51(1) is telling us that we have two major categories of shares. And these major category of shares are simply equity shares, which in business textbooks, they also call it the ordinary shares on the one hand, and preference shares on the other hand. And then the law proceeds to tell us what a preference share is. And after telling us what the preference share is, it says that any share which is not a preference share, as far as Ghana's company law is concerned, is treated as equity share. So if a share does not meet the criteria for preference share, then that share is an equity share. And we have seen what the statutory provision says as far as preference share is concerned, that a preference share can be created in many ways. One, it confers on the holder of the preference share a right to participate in a specified amount of money when dividends are declared. So you are a preferential shareholder with respect to dividends, in which case you have a certain stipulated amount of money which you are going to be given anytime dividends are declared. Or You could be a preference shareholder with respect to a specified amount of money when there's going to be a redemption. Or you could be a preference shareholder with respect to specified amount of money when it comes to winding up. Maybe when we say the winding up, let me put it in context. A company may come to an end in one of two main ways: voluntary winding up, or simply just say winding up, and then the official liquidation or compulsory liquidation. Before the company can actually have a voluntary winding up, it must be solvent. It must be a going concern. It must have the ability to pay for its debts and liabilities as they become due. Let me sip a coffee. So where the company says that, yes, we don't owe anybody, or if you are owing, we have enough money to be able to pay our creditors. Let's pay our creditors and all claims, government expenses, employees' monies and everything. And unless, close down the company, let's share whatever is left. So when it comes to the sharing whatever is left, it will be shared among the shareholders. But we can have a preference shareholder with respect to amount of money in winding up, in which case that preference shareholder will be given his assured money or the specified money before any other shareholder will be given some. But what happens is that if your preference shareholder that you'll be giving you a stipulated sum of money, even if what is left is really huge, under normal circumstances, you may not participate in the surplus left. Being a preference shareholder, especially what we call like the redeemable preference shareholder, you have the right to request the company to give your money back to you, the money you paid for the shares. And then you surrender the shares to the company. So these are some of the permutations on basis of which a preference share may be created. Or these are some of the preferential rights which a shareholder may have. And where your share is with respect to any of these permutations or preferential rights, your share is a preference share and is not an equity share. So an equity share does not entitle the holder to any specified amount of money when dividends are declared or when they are making distribution during winding up. An equity shareholder does not also have the right of redemption, cannot request the company to take the shares and pay its money back to him or her. So let's get that clear as we move on. Okay, so let's take Mafrida. Mafrida.
Sir, please. My question is, it is at all time that a company winding up have that financial capacity to meet the demand of its creditors. Sir, if it is no.
They do say, is it at all times?
All times, yes, please. Yes, please.
No.
So, sir, okay, so if no, what happened to the preference shareholder who has a specified amount demand from the company during winding up when the company have that financial capacity to pay?
When it doesn't have,
Yes, please.
like when it's insolvent, for example. Okay.
Absolutely.
Okay, good. Well, investment is assumption of a risk. And then the bankers and the other financial people tell us, what is your risk appetite? If you are going to have any investment portfolio, if you don't have a strong risk appetite, you may not do certain things. So some of us, we are probably not rich because we have a low risk appetite. We are afraid to take certain of investment, isn't it? And once you're
Yes, sir.
afraid to, you don't get the returns. So in the same vein, your preference shareholder, it's a risk. You are not what do you call the insulated from the risks. If the company is insolvent, you too you are going to also suffer. Now your privilege would only become meaningful where things are well with the company. But if things are not well with the company, things are not well with the company.
Well,
Yes,
okay. Thank you so much, my lord.
very well. Yeah, so if you look at the 51 2, it's not necessary actually because the drafter was just dissipating drafting resources. Because already you've told us in the 51 1 that any other share shall be referred to as an equity share. And then you come to 51 2, a share that is not a preference share shall be referred to as an what? Equity share. Just a S abundantia curtaila. Yeah, out of abundance of question, but that is fine. So now when you are asked to explain an equity share is any share which is not a preference share. But then your answer will not be complete unless you continue to tell us what the preference share is. Because you have told us that equity share is any share which is not a preference share. That is fine. So before I can know any share which is not a preference share, I should be able to tell what a preference share is so that I can say, okay, so this share I have, it doesn't meet the criteria for preference share. And for that matter, it is an equity share. And that is why if I ask you to briefly explain equity share, I will simply say that an equity share, also an ordinary share, is a share which is not a preference share, full stop. I'll give you 1/10 because you haven't done a full response. Another point worth noting is section 51.3 that the meaning of preference share under subsection 1 shall apply to whatever name a company may designate in this constitution. And that provision is really striking because the point about preference share is the core idea, the essence, not so much about the label or the epithet, as it were. It's not the label which makes it a preference share, but the substance. And for that matter, you can use any words at all, so long as the particular share you are given a certain preferential right with respect to other dividends, redemption, income on distribution or winding up. That is a preference share, even if you haven't used the word. So let's keep that in mind. So meaning that if you have any, and especially those of you who are becoming lawyers, right? And especially become lawyers, house counsel or corporate lawyers and so on, and even any other legal work where if you have to ever make some determination or opinion as to whether a company has a preference share. And they say, when you get to the law school, they have this company law in practice. And let's suppose that you're a lawyer for a company, and the company is going to enter into a certain, transaction or investment agreement and so on. So there's something we call the legal due diligence. And then the legal due diligence you do would also include you looking through the corporate documents, the necessary documents of the company to understand the share structure and so on of that company and so on. So part of it will be for you to find out, is there preference share in this particular company we are going to do this business with, or we are going to acquire and so on and so forth. And in trying to find out whether there's a preference share, you're not just looking for the word preference share only. You have to examine critically whether the company by its constitution has, for example, created special rights and privileges attached to a certain class of share. If it has done that, then that should tell you right away that there's a preference share in that company, even if the word preference share has not been used. So that is the point we are trying to make. Now, we will move on to section 52, suspension of the rights, voting rights of the preference share holders. Now, if you remember our discussion last semester of membership rights, particularly under section 34, if you remember that. Under section 34, we made the point that as a general rule, every member has the right to attend a general meeting of the company and to speak and vote on a resolution before the meeting. However, we also noted that in terms of section 34(2), it is permissible for a registered constitution of a company to provide that a member is not entitled to attend and vote at a general meeting unless the cost or any other sums of money presently payable by that member in respect of shares in the company have been paid. So we made that point. And that is why, maybe let me explain the 34(2) before we come to the 52(1), so that it makes more sense to you. Now, if you remember, when we were discussing the preliminaries of shares last week, we talked about issue of shares, payment for shares. And as far as payment for shares is concerned, the point was made that when shares are issued, valuable consideration is supposed to be paid. The most preferred valuable consideration is cash, except that non-cash consideration may also be accepted, so long as the requisite particulars of the agreement have been registered with the Register of Companies. Then we made the other point that it is not mandatory for the shares which are being issued to be paid for upfrontly, like to be paid for immediately. The company can say that only part of the value should be paid, and then the other part will be paid later on. When the company has demanded, which in corporate law you call calls, when the company has made a call for the unpaid value or the arrears to be paid. Now, if you look at section 34, where shares have been issued to you and you have not finished paying for the share, the company can, for example, make the point that so long as demand notice or a call has been served on you to come and pay, and you haven't come to pay, then you will not be allowed to attend general meetings and vote. So that possibility is there, and that is what Section 34(2) is trying to say. Now, Section 52(1) is telling us that despite Section 34, that is, despite all that I have said, the right of holders of preference share to attend and vote at the general meeting of the company may be suspended on conditions. So it is permissible for the company to prescribe special conditions, which will say that if you're a preference shareholder, you cannot attend a meeting or you cannot vote, as it were. So let's look at some of these. So 52(2), despite a provision to the contrary in the constitution of a company, preference shares carry the right to attend general meetings and on a poll at those meetings to at least 1 vote per share in the following circumstances, but not otherwise. A, maybe before we look at the circumstance, let's explain the chapeau, like the preamble of that is the 2, the 52(2). So 52(2) is saying that, yes, the company in its constitution can prescribe conditions under which a preference shareholder may be prevented from coming to attend and vote at meetings. That is permissible. However, there are certain type of situations which are so important that the preference shareholder, regardless of whatever is in the constitution of the company, would always be entitled to attend meeting and vote if any of the following matters are going to be considered. And what are those matters? A, on a resolution during the period that the preferential dividend or a part of the preferential dividend remains in arrears and unpaid. The period starting from a date not more than 12 months or a lesser period that the constitution of the company may provide after the due date of the dividend. So a preference shareholder, if it's respect to dividend, we are told you're entitled to a specified sum of money to be paid when dividends are declared. So let's suppose that the specified sum of money is like the 10% of the value of money you paid for your shares. And we did a computation is, let's say, is 50,000 Ghana cedis. But the dividends declared, the whole dividends for the whole country, for the whole company was just about, let's say, 30,000 cedis. So even if we have to apply 30,000 cedis to you alone, it will not be enough. So let's suppose that there are 3 of such preference shareholders in your category, also entitled to less than 50,000 cedis. So the principle of a pro rata may be applied so that each of you will get something paid, not everything you are supposed to be paid according to your preferential shares terms. So that will mean that the company is owing you more dividends. So that is the scenario the 52(a) is talking about, that where the company is owing you dividends as a preference shareholder. If there's going to be a resolution, you are entitled to attend and vote. And then B, on a resolution which varies the rights attached to those shares. If there's going to be a resolution to vary your right as a preference shareholder, regardless of whatever the company has provided in the constitution, as to whether you are fully paid up, not fully paid up, or whatever, Section 52(2)(b is saying that you are entitled to attend and vote at the meeting. C, on a resolution to remove an auditor of the company or to appoint another person in place of that auditor. Auditors are very important. They serve as a watchdog over the financial health of the company. And of course, as a preference shareholder, you have an important stake in the financial well-being of the company. So therefore, if there's going to be any resolution to appoint or replace the auditor, then the law says that regardless of whatever disabling conditions the company will have stipulated in its constitution, you will still be entitled to attend and vote at such a meeting. And again, on a resolution for the winding up of the company or during the winding up of the company, so if the members are going to pass a resolution that let us close the company, let us wind up, then because we are going to, they are seeking to wind up the company, you'll be entitled to attend and vote, notwithstanding any specific rules in the constitution of the company. So let us keep that in mind. And you should also have some of these things on your fingertips. Now, 52(3), apart from the circumstances in section 34 and subject to subsection 1 and 2, which we have just been discussing, preference share carry the right on a poll at the general meeting of the company to one vote only in respect of each share. So let us keep in mind, when it comes to polling, polling is like where someone said, okay, I want my share to count for me. Okay, so in that case, the rule is that one share, one vote. So if you have 1,000 shares, then you're going to have 1,000 votes. So that's what it means. We are not going to have, there used to be this case known as is it the Brady and Brady? And also Bushel and Fate. I think the case is the Bushel and Fate. Let me write that for you. Bushel and Fate. Please, when I mention a case, or write it. It's not for just cosmetic purposes. It means you should read it. Okay, thank you. So, Bushel, sorry. I think it's here. Bushel versus Fate. Like faith as in, I believe in God kind of faith. So Bushel and Faith, 1970. AC N99. That case, there was a property company called Bush Court, and it owned properties, houses. The essential aspect of the case has to do with voting rules. So the capital of the company was about 300 and has 100 shares. The 100 shares were held by Mr. Faith, and then the other 200 shares by his two sisters, Mrs. Bushell and Dr. Bine. There was a provision in the company's constitution which said that under resolution to remove a director, that director's shares will carry 3 votes each. So pay attention. So there's the provision in the constitution that if a resolution is tabled to remove a director, then that director who is going to remove by the resolution will automatically have each of his shares carrying 3 votes instead of the usual 1 vote per 1 share. So the two sisters, that is Mrs. Bushell and Dr. Byrne, I don't know whether they realized their brother was abusing the resources and so on, as women may not like. So they decided to remove him, and when they passed the resolution, Mr. Faith, he had 100 shares, but because of the Article 9 of the Constitution, the 100 shares gave him 300 votes because he multiplied that by 3. And the other two sisters, because they had altogether 200 votes, what it meant is that their resolution was not successful. So the matter did not sit well with the sisters, so they went to court to challenge the whole thing, and the House of Lords eventually took the position that if you look at the law closely, there was no express provision in any legislation that the lawmaker did not want anything like that to be done by a company. So there was nothing wrong for the company to have put that clause in its constitution that if a director is going to be removed, then that director's vote, that director's share will carry 3 votes per share. And Lord Reid, for example, expressed the view that, quote, with some reluctance, I agree with the majority of your lordship that this appeal must be dismissed. Article 9 of the Articles of Association of this company is obviously designed to evade Section 1841 of the Companies Act, which provides that a company may, by ordinary resolution, remove a director, notwithstanding anything in this article. The extra voting power given by that article to a director whose removal from office is proposed makes it impossible in the circumstances of this case for any resolution for the removal of any director to be passed if that director votes against it. Then he expressed a point which, as students of jurisprudence, will be of interest to us. So, his lordship, Lord Reid, made the point that Giving recognition of the weighted votes, which table A. So table A is like the standard, like a default articles, or just as we have like the various default constitution for companies that decide not to adopt their own constitution. If you go to like the schedules, schedule which you have schedule A, schedule B, and so on. In the same vein, we also have what we call like the model articles, like table A. His logic was of the view that yes, it recognizes possibility of a weighted voting as in like what we saw here, trying to say that okay, under certain circumstances, a share will carry more than one vote. That is a weighted voting. So he expressed that frustration and exasperation, and made the point that, quote, "You must state the law as we find it." Yeah, so a judge, sometimes you may disagree with the law, but the law is the law. You have to give effect to it as it were. So the takeaway is that, yes, it's permissible for weighted voting to be done. However, Section 52(3) is telling us that when it comes to everyday life of the company, like general matters, apart from those special circumstances that we've talked about, preference share carry only one vote per share and not any weighted voting. And not any weighted voting. So let's keep that in mind. So 52(4), a special resolution of a company increasing the number of shares of a class may validly resolve that an existing class of preference shares shall carry the right to vote specified in subsection 3, additional to one vote per share, as shall be necessary in order to preserve the existing ratio, which the votes exercisable by the holders of those preference shares at the general meeting of the company bear to the total votes exercisable at the meeting. So 52(4) is telling us that even where it becomes necessary for the company to issue more shares with respect to a particular class, if there's a class of preference shares holders who had a certain privilege in terms of having more say when it comes to decision making by virtue of the combined effect of their shares together during voting. Now, that will not have to be diluted. The company will need to respect that. So if the increment in the number of shares of the class which the company is going to do will have the effect of actually watering down or diluting the privilege which those existing preference shareholders have when it comes to voting, then more votes will have to be given to them so that the original advantage they had when it comes to decision making will not be taken away by the increment in the number of shares of the class, which the company is trying to do. But let's take Manfield. Yes, let's hear you, Manfield.
Okay. Counsel, please. Sorry, my lord, please. On the suspension of the voting rights of preference shares, I was just pondering on it. Says so. Please imagine a preference shareholder has, let's say, have 100 of shares in a company, and he have paid 70 of them, and 30 is unpaid. So say, based on section 52 of the Companies Act, it states emphatically that a preference shareholder may not be allowed right to attend a meeting and to vote may be suspended on a condition. And when we get to the section 6, it also says that section 36 also says that the right a company may include in its constitution that any sum that is presently not paid by a shareholder, it may deny the person from coming to the meeting or having a vote. And when we also proceed to section 52(2), it also says that a preference shareholder can have 1 vote per share. So say in this situation, if I am a preference shareholder in a firm, and then I have 70% of my shares paid and 30% of my shares unpaid, will I still be denied the opportunity to be at the meeting and to vote per my 70% shares that I have in the company?
No, I think we are messing up a number of things. The law provides different scenario. The law has a general position, and then it goes on to create exception. The general position is that each share has 1 vote. That is the general position. Another position is that the company can provide in its constitution circumstances under which a person may be prevented from attending and voting, particularly where there has been a call on you to come and pay for your unpaid shares. The company can say that, yes, if calls have been made on you to come and pay the unpaid value of your shares, then you will not be allowed to attend and vote, as it were. Now, quite apart from that, other conditions, especially when it comes to preference shareholders, may also be stipulated by the company. We cannot exhaust them. However, there are certain matters which are so fundamental in the sense that they impinge directly on the rights of the preference shareholder. And those are protected areas. And that is why the law says that as far as meetings to pass resolution on those matters are concerned, regardless of whatever the company has provided in its constitution, the preference shareholder must necessarily be allowed to participate in the relevant resolution. In that case, it will not matter whether the preference shareholder has finished paying or has not finished paying for the shares that have been given to him or her. But from the point of view of business prudence and some economic thinking, one would like to hold the view that it is more likely the case that for preference shareholders, the company will always ensure that they have fully paid for the value of their shares, because, mind you, they enjoy super privileges. So if the holder is going to enjoy special benefits, why not make sure that he has also given full value of the shares to the company already?
Yes, sir.
Yeah, so I think from the business prudent point of view, one would argue that in practice, you're not likely to have a lot of cases of unpaid value. But for theoretical cases, as we are doing, we can consider it. But even where that is the case, as we have noted, the law has given special conditions or instances in which the preference shareholder should not be prevented from attending or voting on certain types of resolution.
Thank you so much, my lord. I'm grateful.
So let's take section 52.5. Yeah, 52.5. For purposes of subsection 2, a dividend is due A, on the day immediately following the expiration of the year or other period, or B, where a company has a registered constitution on the date appointed in the constitution for the payment of the dividend for a year or other period, whether or not the dividend has been earned or declared. So for preference shareholders with respect to dividend payment, they have a certain specified amount of money to be paid at dividend whenever dividends are declared. So section 52.5 is giving us the timeline for purposes of preference shareholders relating to dividends. When can we say that dividends ought to have been paid by the company and then the company is in arrears? Because that one is necessary for triggering the provision of the law, which says that even where there are some other conditions prescribed by the company in its constitution, when certain resolutions are going to be paid or certain things are happening, the preference shareholder will still be entitled to attend and vote on the meeting. One of them include where there has been arrears of dividends. The company is owing the preference shareholder dividends. Then automatically is entitled to attend and participate in any resolution as it were. Now we have seen the doctrine in Bushell and Fate, the weighted voting principle, and its relationship with section 52. We will now discuss votes of equity shares with respect to section 53. Subsection 1 to the effect that despite a provision to the contrary in the constitution of a company, equity shares shall carry the right on the poll at the general meeting of the company to one vote only in respect of each share subject to section 34. So the takeaway from section 53.1 is that it's not permissible for equity shares to have a weighted voting rights. So weighted voting right, like the ones we saw in Brady and Bushell and Fate, cannot apply to equity shareholders, because 53.1 is saying that equity shareholders or equity shares carry one vote per share. When there's going to be a poll, that is, usually when we are having meetings, there are various ways of coming to a decision. If for nothing at all, you follow proceedings in Ghana's parliament and in other parliaments, where we have what we call like the voice vote. As many as are for this resolution say aye or say yes. Then if the vote is, the voice is okay, it's taken as approval. Or you can have people raise their hands, in which case head count. Or you can have a ballot, poll, secret ballot, as they may call it. Now, for company, when it comes to poll, especially the ballot, is going to be one share, one vote. Now, thankfully, now with the technology, you go to meetings and they have the database. So when you vote, the computer can multiply, can get the number of shares that you have and say, okay, Mr. X has voted, but he has 1,000 shares, so he's cast 1,000 votes. So that is how it is. So that one is easier. So 53(1) is saying that for equity share, ordinary shares, you have 1 share per 1 vote. No more, no less. Now, it is also possible for the rights attached to preference share, especially regarding voting, to be changed so that they become equity share. Now, preference share can have weighted voting right, as we saw, like the Bushel and Faith, but there can also be variation of class right in which that voting, that special voting right, like the weighted voting, attached to them is, for example, taken away, so that henceforth, each of the shares that the preference shareholders have will carry just 1 vote. Now, where that is the case, despite the fact that previously it had been issued as a preference share, the law will now reckon it as an equity share issue. So that is the point about 53(2). Now, let's look at some general principles of interpreting or construing class rights. And it's also tie in with what we'll be discussing already regarding classification or categorization of shares, particularly preference shares. So 54, in construing the provisions of the constitution of a company in respect of the rights attached to shares, the following canons of construction shall be observed. So let's suppose that you have a particular case. The company's constitution is there. Certain shareholders are trying to assert certain rights and say that by virtue of this shares issued to me, I'm supposed to have these rights which other shareholders are not entitled to. So this is where it may be necessary to actually construe, necessary to interpret, to understand the true nature and scope of rights attached to that particular share. And that is where the principles in section 54 becomes handy. So section 54 are general rules of thumb, canons of construction, which help us in trying to navigate such situations. So 54, in construing provision of the constitution of a company in respect of the rights attached to shares, the following canons of construction shall be observed. A, unless the contrary intention appears, a dividend is not payable on any share unless the company resolves to declare that dividend. So let us understand that whether you are a shareholder, preference shareholder, or anything, the general rule is that dividend is not payable unless the company resolves to declare that dividend. But again, unless the contrary intention appears, this is where the provision we read, section 52(5), becomes important. Because 52(5) tells us that if you are a preference shareholder, as we saw, like 52(2) told us that despite provision to the contrary in the constitution, a preference shares carry the right to attend general meetings on a poll at those meetings to at least 1 vote per share in the following circumstances, but not otherwise. Then the A, on a resolution during the period that a preferential dividend or a part of a preferential dividend remains in arrears and unpaid, the period starting from the date, not more than 12 months. So now question is, when did the preference shareholders respect to dividend? when did he become entitled to his dividend, which the company is owing? So that is where Section 54A becomes relevant. Now, unless the contrary intention appears, a dividend is not payable on any share, unless the company resolves to declare that dividend. So for preference shareholder, it will depend very much upon how the terms of the issue were catched or formulated. But apart from that, with respect to equity shareholders and all that, you cannot say that dividends should be paid to you where the company has not passed a resolution declaring dividend. So that is very important. And that is why when we're discussing the nature of shares, we said that share is a shows in action, not a shows in possession. So you cannot just take over some of the assets of the company and say that, why is it that I have sunk money into this company by way of shares? And for 5 years, I haven't received any dividends. So I'm going to sell some of the cars or buildings of the company. You don't do that. On the other hand, where you have evidence that dividends have been declared or a certain formula has been provided for dividends to be paid and they are being ignored, then you go to court and seek legal enforcement of that. 54B, unless the contrary intention appears, a fixed preferential dividend payable on a class of shares shall be cumulative. In other words, a dividend is not payable on any shares ranking subsequent to that class of shares until all the arrears of the fixed dividend have been paid. So if, for example, you have been given fixed preferential dividend, let's say that you have a 5% dividend, 5%, let's say, referable to maybe the total amount of money you paid or whatever. So dividends is declared. We've done the computation. Now, if you look at the amount of money which the 5% comes to, let's suppose that there are other preference shareholders in the same class as you, right? In the same category as you. So the dividend declared is not huge. So we need to use the pro rata principle or the proportionality principle to try and spread it for all those preference shareholders within that particular class that are entitled to fixed preferential dividend. Now, that is done, and more dividends ought to have been paid to you, but not enough is available. So the company is owing you. So in that case, next time dividends are declared, the part of the dividend which remains unpaid to you from the last season when dividends were declared will have to be paid first to you. And after that, you still have to be given your current share before any other shareholder in the other classes will be given theirs. And that is why we say that as a general rule, fixed preferential dividend payable on the class of share is cumulative. Cumulative means that it builds up until all that you're entitled to be paid are paid off. Otherwise, the arrears will have to be paid before any other person. Then 54C, unless the contrary intention appears in a winding up, arrears of a cumulative preferential dividend, whether or not earned or declared, is payable up to the date of actual payment in the winding up. Yeah, so if you are preference shareholder with respect to dividends, your interest in the company is all about that. And for that matter, if it becomes necessary that the company should wind up, then you are going to be paid both your accrued and non-accrued preferential dividend up to the date of actual payment in the winding up. That is the date that a decision was made that the company should be wind up. 54D, If a class of shares is expressed to have a right to preferential dividend, then unless the contrary intention appears, that class does not have a further right to participate in dividends. Yeah, so the general rule, and as I say, general rule, meaning that it's possible for the exception to be made. The general rule is that if you are a preference shareholder and your preference shares with respect to dividend, meaning that you are entitled to be paid your dividends first, or you're entitled to have a fixed sum of dividend paid, then the general rule is that when you have had your dividend paid, either the particular fixed sum or the fares will be paid. Once that is done, you cannot participate again in any remaining dividends. So you become a non-participating preference shareholder with respect to dividends, meaning that once you get your stipulated amount of dividends, you don't participate in any, which will be less. It doesn't matter that more dividends is left. You have no share in it because you've had your stipulated sum paid to you. So if you are preference shareholder, that is the other downside. If the company has, for example, been very successful, but because you have like a specified amount of dividend, that will be paid to you, all right. But when it is paid, then you are finished. You cannot participate in any other dividends again. But the advantage is where the company does not have much, then you are assured of getting almost all your fixed sum of dividends. 54E, if a class of shares is expressed to have preferential rights to payment out of the assets of the company in the event of winding up, unless the contrary intention appears, that class does not have a further right to participate in the distribution of assets in winding up. So this is application of what we just discussed, but now in the context of distribution of assets in the winding up. We have some preference shareholders whose preferential statutes relate to payment of assets of the company during winding up. That is to say that when the company is being folded up, is winding up, coming to an end, when assets of the company have been gathered and the various creditors have been paid, money is left or assets are left. Those assets have to be distributed to shareholders. But if you are a preference shareholder with respect to payment out of the remaining assets, now you will be given your share of the remaining assets first. Now, when you are be given your share of the remaining assets, and even if more assets are left, you will not be allowed to participate because you are a preference shareholder with respect to, if you like, a guaranteed payment out of the assets of the company in event of winding up. So once you've been sorted out, that is it. You'll not be given any more. 54F. In determining the rights of the various classes to shares in the distribution of property of the company on winding up, consideration shall not be given unless the contrary attention appears to whether or not the property represents accumulated profits or surplus, which will have been available for dividend, while the company remain a going concern. Good. So when the company is winding up and we need to distribute the property, what 54F is telling us is that it will not matter whether the value of the property to be distributed could have been treated as dividends assuming the company was not winding up and it was like a going concern. As a general rule, it's not necessary to do that. All that matters is that creditors have been paid and we still have assets left. So those assets should be valued and then distributed to the shareholders, as the case may be. And 54J, subject to this section, the shares rank equally in all respects, unless the contrary intention appears. Yeah, so 54J is telling us that apart from these special rules, which we have discussed under 54, apart from that, in any other situation, shares are to be treated in the same way. There should be no discrimination. But of course, the only discrimination will be where there's a contrary intention. For example, as in, if you have like a preference shares, and then specific terms are stipulated in the issue, then that will be it. But otherwise, a share is a share. So let us keep that in mind. Okay, so we will end the discussion here for the day, and we continue during the week. If there are questions, we will deal with them, and then we will end. Okay, I've not seen any hand up, so I presume all is well. So have a good day, and then we shall be in touch on the platform for other arrangements during the week. Thank you.